Ladies and gentlemen, welcome to Georgia Court News. Today we've got a good program for you. What we have here today is yet another perfect example of what we try to do here on Georgia Court News. What we try to reveal to we the people. And that is when our officers of the court manipulate our judicial system in order to procure a conviction. Now, our sacred judicial system is the moral fabric that holds our society together. We have our judicial system and we have our religion. Those are the only two things we have that hold our society together so that we may have a functioning society. So when we have one of our trusted officers of the court who manipulates that system, that's one of the worst problems we can have. And that is what we strive to reveal here on Georgia Court News, and we've got one to show you today. Now, this is a case about a young man named Earl Marcellous Windhom. Mr. Windhom is convicted of armed robbery. He had a co-defendant. The co-defendant's name was Christopher Graddick. G-R-A-D-D-I-C-K. Excuse me, I've got a summer cold coming on. In this case, now see the importance, what we the people have to realize. Yes, of course, we want the people out here committing crimes, and we've got a terrible problem with crime right now. We can't, it's hard to even go to the grocery store and get out of your car without somebody snatching your purse. It don't matter what part of metro Atlanta you're in, it's happening everywhere. So we want our criminals, we want them locked away. We want that done. But it has to be done in accordance with the procedures that are established by our constitutions, our Constitution of Georgia, our Constitution of the United States. It has to be in accordance with the procedural rules. It has to be in accordance with the statutory requirements. And it has to simply be done right. In this case, there's simply an accusation that Mr. Windhom committed an armed robbery. There's no eyewitness. The victim can't testify against him. They can't say that it's him. There's no camera footage. There's no fingerprints. There's no DNA evidence. But here's what happened. Early on, when they get the charges, Mr. Windhom gets the public defender appointed to him. And Mr. Graddick gets a different public defender appointed to him. Well, Mr. Graddick's public defender started noticing some things about Mr. Graddick that just didn't sit right. The things just didn't, he wasn't comprehending things correctly. And so the public defender for Mr. Graddick filed an order requesting a psychological evaluation of Mr. Graddick. And the court granted the psychological order, and the psychological order came back, and we have a copy of it right here. And the psychological order determined that Mr. Graddick was clinically retarded, mentally retarded. Now, those are not my words. Those are the words of the mental evaluation, the clinic that examined this young man. He's mentally retarded. He does not understand the adversarial system. He does not know the difference between right and wrong, does not understand the difference between a guilty plea and a not guilty plea. The boy's just out there. He don't get nothing. So they determined that he was incompetent to stand trial. All right, now I can just imagine, this district attorney is looking for a quick resolution to this case. He wants to get a conviction and get it over with and get to some of these other cases he got backed up. So he sees this weak link in Mr. Graddick, and I'm sure he was going to have that case resolved through Mr. Graddick. Well, he resolved it through Mr. Graddick anyway, but what he did, since this young man was not able to stand trial, was not competent enough to stand trial, he just decided he'd get Mr. Graddick to testify against Mr. Windhom. Mr. Graddick, clinically mentally retarded, is the only witness, the only testimony that convicts Mr. Windhom of armed robbery. Now, we the people, you and I, we don't need to debate this, because we understand that just palpably on his face, this is entirely wrong. We don't need to go into the details and point out that, well, if he's incompetent to stand trial, he's incompetent to testify. We know that, and everybody else knows that. But this is what these officers of our court have done in this case. They used a mental retard to testify against this young man, and they have sent him way down to a South Georgia prison for many a year. They loaded him up with some time now. Okay. The thing about it is, what I need to explain here, we got 150 some odd counties in the state of Georgia here. Each of them have their own independent courthouses, and some of these in the metro area, these courthouses got multiple courtrooms in there. And on any given day, you can walk in any courtroom, and what you're going to see, you're going to see the judge up there on the bench, you're going to see the prosecutor over here to one side, you're going to see the defense attorney over to the other side, and you're going to see the defendant sitting there at the table with his defense attorney. There's not going to be anybody else in the courtroom. There's not going to be anybody else in there. He might have his mother in there, and there might be a wife in there or a family member, but there's nobody in these courtrooms watchdogging them. There's nobody watching to make sure they do what they're supposed to do. There's nobody in there watching to make sure they do everything in accordance with our judicial system. These judges and these prosecutors and even the defense attorneys, they gaggle right in there with them now. They've got the leeway to do what they want to do. And I am here to tell you, and not only tell you, I'm going to demonstrate for you, do what they want to do is what they're going to do. So, you imagine yourself with a charge you're not guilty of, and they prop you up in front of a judge, and then they got no evidence against you. Well, this case right here demonstrates that they can just walk down the street somewhere and find some retard sitting over up against the wall, drooling down his shoulder, give him a ham sandwich and bring him back into the courtroom and get him to testify against you. And the next thing you know, you're loaded up on a bus and you're shipped way down to a South Georgia prison with so many years you ain't never going to come up for air. Nobody wants to hear anything you got to say. And wait till you see what happens next. Okay, I met with Mr. Windhom and we went over this case, and I said, well, look, this is the only evidence they got against you. This evidence is part of the record. The state is claiming that they've got competent evidence against you to justify this conviction. So here's what we'll do, Mr. Windhom. We'll file a plea of null-till record. A plea of null-till record, what that is the state, when the state claims they've got competent evidence against you, pardon me, we're claiming that they have no competent evidence against you. So we file this plea of null-till record saying there's no competent evidence contained in the record to justify this conviction. We're going to say that the sole evidence is the testimony of somebody who is not competent to stand trial. When we file this plea of null-till record, now the state has got to demonstrate that they have a witness that is competent to give evidence against you. Now, as I explained to Mr. Windhom, we can't bring any more witnesses in for this hearing. This is not a hearing to introduce new evidence. You can't introduce any new documents. This is a trial only of the record. It's a trial of the record. We're going to look at what's contained in the record. That's what a plea of null-till record does. If the state can prove that they had a competent witness and that testimony is enough to uphold your conviction, well, you got to stay down here in this South Georgia prison. If the state cannot show that they had a competent witness, well, they got to let you go. And since we've got right here a medical diagnosis that says this man is not competent to stand trial, well, obviously he's not competent to give testimony to send anybody else to prison. So it looks like they're going to have to let you go. I mean, it's pretty cut and dry. They got to let you go, Mr. Windhom. All we got to do is go down here and have this court hearing. That's all we got to do. So Mr. Windhom, he gets excited. And I'm excited for him. And we filed a plea of nullity of record. Now, in addition to the plea of nullity of record, we want to make sure Mr. Windham's in that courtroom so he can argue his case, although he don't need to argue his case. This plea of nullity of record lays it out. All you got to say is one thing. The solitary witness that the state used to convict Mr. Windhom is not competent to give testimony. And we attach the mental evaluation to the motion. What else do you need? So Mr. Windhom really does not have to be in that courtroom, but he wanted to be there. He's got a right to be there. The Constitution provides that he can meet his charges. So we file a application for the writ of habeas corpus ad testificandum. Now, the writ of habeas corpus ad testificandum is under Title 24. And it's a procedure used that a lawyer can use or the criminal defendant himself can use when any set of circumstances when a criminal defendant who is locked up somewhere in prison or in jail needs to be in court somewhere else, he can file a habeas corpus ad testificandum. You file that application for habeas corpus ad testificandum, then the judge just writes the order and they ship you wherever it is you need to go. It's real simple. It's used all the time. I've used it hundreds of times, and it's a real simplistic procedure. And anybody that's in the judicial system is very familiar with the procedure. It's a common procedure. And then you have a different type of habeas corpus, and it's under a different title in the law book. You got different titles. You got titles 1 through 24, 1 through 50. This title for habeas corpus ad testificandum is in Title 24. There's another habeas corpus procedure that's in Title 91445, I believe it is. And that habeas corpus is simply for attacking your conviction. You attack the constitutional errors that may be in your conviction, contained in your conviction, where they violated your constitutional rights while obtaining that conviction. Two different procedures altogether. So, we filed the habeas corpus ad testificandum and the plea of nullity of record. Well, the judge and the prosecutor, they get that plea of nullity of record down there in the mail. Clerk files it, sends the judge a copy. We sent the district attorney's office a copy. Excuse me. And I can just imagine them seeing that paper. I mean, it's cut and dried. I've explained it to you. We, the people, you understand it as I explained it. I can just imagine them getting that paperwork and they say, Lord have mercy, how did this fella figure this out? Well, we can't bring this fella down here for a hearing and get this hearing on the record. If we get a hearing on this plea of nullity of record, it's going to cause us some problems because people are going to see how we manipulated this judicial system in order to send this man down to a South Georgia prison. We can't let people see that. We cannot let people see how we have given false statements of material fact, made false statements of material law, and just did what we want to do down here in Peach County. We can't let people see that. So what are we going to do? Now, I'm going to tell you what they did. First, I got this buddy I want to tell you about. I got this buddy. He's a roofing contractor. His name's Carlton. Carlton loves to talk to me about the law all the time. He'll read something in the law book and he'll come run over to me and want to talk to me about it. And I'm going to tell you, he just don't get it. He just don't get it. He'll read something and I can't believe the interpretation he puts on it. It just blows my mind. It just goes to show that typically roofing contractors don't know or understand the law. Now, I'm a swimming pool contractor. I build swimming pools. I completely understand it. I know and understand the law. And, you know, swimming pool contractors, we know and understand the law, but this roofing contractor, he just don't get it. Now, I said all that to explain that when the judge writes this order, I got this order right here. He begins this order by saying, it's an order dismissing defendant's plea of nullity of record and petition for a writ of habeas corpus ad testificandum. Pending before this court is defendant's plea of nullity of record and application for a writ of habeas corpus ad testificandum. The court will first address the application for a writ of habeas corpus ad testificandum. So he's got the name of the procedure right and the pleading that we filed. But then he says, under OCGA Title 9, 1445, service of a petition for habeas corpus shall be made upon the person having custody of the petitioner. You see, this is what they can do down there in that courtroom. This is a sitting judge that's been on the bench for I don't know how many years, but he's worked his way to that bench, and that means he's got to know and understand the law. And look here. My roofing contractor's going to know the difference between Title 9 and Title 24. That's simple mathematics. My roofing contractor's not going to make this mistake. But this judge down there in Peach County, Judge David L. Mincy III, I just wonder what the first two were like. Judge David L. Mincy III, he writes this order. It's a whole front page telling about how Mr. Windham has not complied with Title 9, 1445. And he goes into detail about all the things he didn't do. Well, we didn't file no habeas corpus under 9, 1445, Judge Mincy, and you know that. And you know that. And you're just doing what you want to do down there in Peach County. And we filed a plea of application for habeas corpus ad testificandum under OCGA Title 24-1362, and you know that as well, sir. You're just thumbing your nose at us, and you're just, reaching over across the benches. Might as well be slapping us in the face one time with this order you've written here, sir. And, After Judge Mincy denied this plea of nullity of record and the habeas corpus ad testificandum, Mr. Windham, he appealed this order. And it went to the Court of Appeals. And the Court of Appeals, now this whole situation goes to the Georgia Court of Appeals. You would think that a whole panel of judges would have caught that Mr. Windham didn't file a habeas corpus under OCGA 9-1445 and that he filed one under OCGA 24-1362. He didn't file one under Title 9. He filed one under Title 24. You'd think that a whole panel of appellate court judges would have caught that, and I'm sure they did. But what they ruled, they just followed this judge's lead down there in Peach County. You see, they all come out of the same basket, And what they ruled is that the appeals court don't have jurisdiction to hear habeas corpus cases under Title IX. Only the Supreme Court does, which is a fact. So they sent it up to the Supreme Court of Georgia. Supreme Court of Georgia gets it, and here's what they say. Appellant was convicted of armed robbery and recently filed in the court of conviction a plea of nullity of record, in which he essentially alleged that his conviction was void because the principal witness against him was incompetent to testify against him. He also filed an application for the writ of habeas corpus ad testificandum, seeking to be brought to court for a hearing on the nullity of plea. See, the appeals court, the Supreme Court, they got it right there on the first few lines, and recognized the documents for what they were and wrote it in their document and said, we don't have jurisdiction over this, so we're going to send it back down to the appeals court. See how they do you? This boy's down there with the evidence right under his nose to free himself, and you see how these courts are doing it? They're saying, Lord have mercy, what are we going to do about this? When this gets out, They're going to see we're doing what we want to down here instead of following the law. What are we going to do? Well, let's just toss it back and forth for a little while and see if we can't get it figured out. That's what they're doing. All right. So, back to this order that Judge David L. Mincy III down in Peach County wrote. On the second page here, this is where he slaps you in the face. This is where he thumbs his nose at you and just slaps his face. Slaps every one of us, we the people. He slapped every one of us in the face right here. He said, how do you like that, we the people? I'm slapping you right in your damn face. He says right here, in addition, an issuance of a writ of habeas corpus ad testificandum is predicated upon a prisoner showing that the ends of justice require his presence. Well, no, wait just a minute. His whole front page, he's talking about a habeas corpus under Title IX. I thought he was mistaken and thought it was Title IX, but right here he's acknowledging that he knows what that document's all about. He just acknowledged that it's to require his presence for this plea of nullity of record. He just wrote it right here in this document. See how he just slapped every one of us right in the face. He said, how do you like that, we the people? Smack! Slapped every one of us right in the face. So he says, what he says here, he says, in addition, an issuance of the writ of habeas corpus ad testificandum is predicated upon prisoner showing that the ends of justice require his presence. To demonstrate need, the prisoner must show what he expects to prove and how that proof bears upon the case. Here, the defendant has failed to make a showing of what he expects to prove, and as such, he has demonstrated no need. For all the reasons listed above, the defendant's application for the writ of habeas corpus ad testificandum is hereby dismissed. And he goes on to say, lastly, the defendant predicates his plea of nullity of record on his anticipative grant of an application for a writ of habeas corpus ad testificandum. Since his application for a writ of habeas corpus ad testificandum is dismissed, his plea of nullity of record is also dismissed for the reasons listed above. Wow, Judge Mincy. Now, I got this plea of nullity of record right here. Where did it go? Where did it go? There we go. All right. Judge Mincy says that to demonstrate need, the prisoner must show what he expects to prove and how that proof bears on the case. Well, starting right here, Judge Mincy, I'm speaking to you, sir, Judge Mincy. Right here on this plea of nullity of record, number 2, it says that the conviction against the defendant, Earl M. Windhom, rests on the testimony of a single witness, Christopher Allen Graddick. Now, Judge Mincy, that's what he intends to prove. And he's going to show you how that bears on the case right here in number 3. Now, listen to this, Judge Mincy. That, per order of the trial court, the Georgia Department of Behavioral Health and Developmental Disabilities found that the principal witness, Christopher Allen Graddick, to be mentally incompetent. Now, Judge Mincy, he just said that that boy was mentally incompetent. Per an order that you wrote, you're the one that ordered this boy be evaluated to find out whether he's competent or not. So they said he was not competent. You had to get a copy of the order, so you know he's not competent. And he's going to show you that that's what you did. And he's going to show you how that bears on the case. Judge Mincy, how'd you miss that? Number 4, Judge Mincy. That pursuant to the court-ordered competency evaluation, Christopher Allen Graddick suffered from mental retardation, post-traumatic stress disorder, and does not know the difference between pleas of guilty and not guilty, and does not understand the adversarial nature of the court system. Well, that's something he intends to prove, Judge Mincy, and how that bears on the case. And Lord have mercy, look how it bears on the case. If he don't understand any of this, how can he understand how to testify against Mr. Windham? Judge Mincy, how'd you miss that, sir? It's right here under number 4. Okay, let's read number 5, Judge Mincy. Just don't go anywhere. Listen to this, Judge Mincy. That because the state's solitary and principal witness is incompetent, there is no corpus delicti contained in the record. And before the state may obtain a conviction, it must prove the corpus delicti beyond a reasonable doubt. Corpus delicti, meaning the body of a crime, requires that the state prove that it was charged that the crime charged has been committed by someone. Now, Judge Mincy, this is what he intends to prove in the court and show how it bears on the case. And I mean, it's self-explanatory. I mean, this document just frees this man up as far as any... I mean, my roofing contractor would get this, Judge Mincy. How'd you miss this, sir? I tell you what I think. I think, Judge Mincy, we might need to get you tested. We might need to send you down to the Georgia Department of Behavioral Health and Developmental Disabilities and run a test on you, sir. Hook a few little electrodes to your ears or something, see what's going on in between them. We know what's going on, sir. You down there doing what you want to do. You're not practicing law down there. You're down there sitting on that bench doing what you want to do. That's what you're doing. And this prosecutor down there, K. David Cook, Jr., now I don't know if he actually prosecuted that case. I doubt it. I hadn't found out the prosecutor's name yet, but I'm going to pronto. And it don't matter which assistant district attorney prosecutor. The district attorney is responsible for it. So this is, this is another demonstration about how you and the prosecutor, and this goes on in every courtroom, y'all just in cahoots. You're not independent entities in that courtroom. You don't have the prosecution over here and the judge over here and the defense over here and the judge up there mediating these two fellas down here, the defense and the prosecution as he's supposed to be. What you got this defense attorney standing over here and you got this judge up here working with this prosecutor. I mean, it's obvious because if the prosecutor's doing his job, he's supposed to say, whoa, 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 wait a minute there, Judge David L. Mincy III. He's supposed to yell at you. He's supposed to say, we can't use this witness as a testimony to send this man to prison, because the prosecutor's job is to seek the ends of justice, not just to convict. So the two of you got to be in cahoots together. Y'all down there in Peach County just doing what you want to do, ain't you? Well, Judge Mincy, I'm going to tell you what we're going to do. My name's Richard Bradford, and this is Georgia Court News, sir. And you, sir, are a disgrace to the bench. We're going to try to get you off that bench. We don't want you up there no more. We're going to be filing a complaint with the Judicial Qualifications Commission. I'm putting all of this up on Georgia Court News website, podcast. I've got all the documents for everybody to see, we the people. And sir, I get up at 4:30 every morning. I work till 10 o'clock every night. And I'm going to be publicizing your case just as far as I can publicize it, as efficiently as I can publicize it. I'm going to make sure that everybody I can knows how you conducting yourself on the bench down there in Peach County. We're going to get that complaint filed against you, and we're going to see what other kind of actions we can take against you. We're going to see if we can't get you off that bench. We're going to get Mr. Windhom some relief. He's down there in prison, and he shouldn't be. Now, if he's guilty, that's one thing. That's it. But you got to convict him. You have not convicted that man. You just sent him to prison because you wanted to. And we're going to see about getting him some relief. This is Georgia Court News. This is the end of this podcast.